Hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Okay, good morning, Council, and good morning, everyone. Welcome to the June 5th sitting of the Massachusetts Appeals Court. I am Justice Maldonado, and I am fortunate today, and so are you, to be joined by Justices Henry and Justices Wendlandt, and we are your panel for this morning. We have 3 cases on the list, and I want to thank you all for agreeing to do virtual hearings with us. The rules pretty much are the same. 15 minutes on each side, no time for rebuttal. The panel has reviewed the cases, your submissions, and are prepared for your arguments. If you use your time by getting to the heart of your arguments if you want to. If you've done all your arguments, the 15 minutes are not done yet, you'll feel free to rest. If, however, your 15 minutes are completed, rest assured that all your arguments will be considered if you haven't gotten to them. We don't have the normal time clock that has the yellow and green and red, but we will have a time clock that replaces the seal, and it will count down until it gets to the end of the 15 minutes. So you'll be able to see how much time you have left on the clock. And if there are any audio or technical difficulties, the first thing you should try to do is to log on and re-log in. If for some reason you get frozen and get disconnected. We'll do that a couple of times. If that doesn't work, we'll try audio. Then we'll have to go to audio. If we don't have your phone numbers, you'll get a message from the clerk to go by email to let you know what to do next if for some reason there are any technical difficulties. So far, we've been pretty good, but there have been glitches. So I just want to warn everyone about that. With that said, I will call the very first case, John Doe number 58574 versus Sex Offender Registry Board, and we will hear from Attorney Elliott.
Good morning, Your Honors. May it please the court. This is an appeal from a Superior Court decision where there was an abuse of discretion by the hearing examiner in the underlying decision. Specifically, the hearing examiner abused his discretion by denying a timely filed motion for funds for the petitioner to have the assistance and most likely the testimony of an expert medical witness at his sex offender registry hearing. This denial was, in circumstances of this case, was arbitrary and capricious.
Now, counsel, the hearing officer did give credence to mitigation based on a serious illness. Is that correct?
Yes, on factor 31, the physical disability factor, the examiner gave what he called moderate weight. But what's very telling is right after he said, I'm giving petitioner or Doe moderate weight, he said, he then added, the extent of this condition is unclear. In other words, you have the hearing examiner actually confessing that he would benefit from more knowledge about this. In other words, he may have been on the fence between moderate and full credit or full weight for that particular factor. And this highlights why there should have been an expert allowed in this case.
What expert are you proposing?
Well,
it seems to me if that's the case, you're only talking about how, and I'm not saying one interpretation that you want us to give it, is that the hearing officer may have thought that his condition was more severe than what he gave him credit for. Is that your claim?
Yes, yes.
So what kind of expert would have been able to tell how severe?
Well, I was not petitioner's counsel at the hearing level. I think that the expert that he was looking for would have been a medical doctor who was versed in evaluating hepatitis C, which was the condition that Doe had and currently probably still has because it's a chronic condition. And also in 2008, he had interferon treatment for this condition, and that had significant side effects. That he testified, that the petitioner testified at the hearing, in terms of lethargy and causing him to have to seek out the facilities of a bathroom 5 or 6 times a day. And these physical, to answer your question, the expert would have evaluated these medical conditions and also the effect possibly that it had on his sexual drive and his libido.
Counsel, where the defendant did not say himself that he had a diminished drive or that his sexual function was diminished or impaired, why is it arbitrary and capricious to deny funds for an expert witness?
Well, I think in this particular case, obviously, the petitioner himself is not a doctor. He's not a medical expert as regards himself. But his exact statement was he couldn't determine what his sex drive was because he was in prison and he was not interested in male inmates, so that he actually didn't know. So he didn't. I don't think he said that his sex drive was definitely compromised. He said, he said he didn't know. And once again,
but
Is that something you wouldn't know? I'm sorry.
Yeah, go ahead.
No, go ahead, Justice Wendlandt.
Well, I guess given that he didn't know, and our standard is, I think, abuse of discretion. If, maybe if I were the hearing examiner, would have allowed the funds, but that's not my standard. It's, is this outside the range of reasonable alternatives, right?
I think that when it comes to physical condition, the reason why physical condition is so important when it comes to these classification decisions, I mean, there are 2 reasons. One is if someone is so incapacitated that they don't have the energy to get around, they can't do anything, they're probably going to be less of a threat. And he did testify that he was very lethargic, that he had trouble motivating himself from time to time. So you have the physical component, and then you have the sexual libido component, which also factors in to.
There's 2 problems with the sexual libido problem. One is that if the interferon was it was the combination of the Hep C and the interferon treatment. The interferon treatment ended in 2008. Why would anyone think that so many years later, isn't it, he would still be suffering any side effect, a particular side effect that he didn't even claim to have had?
Well, he did say that he did testify that he was still suffering from the side effects, even though it was a long time ago. I think that his doctor wanted to switch him over to a different kind of treatment that was not interferon, but he definitely testified during the hearing that his stomach had been messed up by the treatment and that had not resolved. The other reason why I think that the court should consider the sexual drive, sexual libido issues is because the articles that his attorney introduced actually focused on those. There were 2 scholarly articles, and each one went to quality of life issues, but one was specifically entitled Effect of Hepatitis C on Sexual Drive. And so that the articles themselves established the nexus that the attorney had to, that the attorney was required to establish under the the seminal case in this area, which is the 2008 82029, I think.
So I guess that brings me back to Judge Maldonado's, or maybe it was Judge Henry's question, as to what kind of expert your client was seeking to retain. Wouldn't it be somebody along the lines of, with the same background or similar background to the authors of the study?
I think that's correct. I think that's correct. In other words, there has to be a connection. The scholarly articles would have most definitely focused on that. And, the case law is fairly clear that the Doe has to establish that there is a medical issue particular to him. So I think we've got like two medical issues particular to him, the interferon and the hepatitis C, which is not resolved. And by the way, hepatitis C is a debilitating condition of which it's the 9th leading cause of death in the United States. And the other thing is the medical documentation in this case was not extensive, but in terms of volume of pages. But if you look at the actual note, I think it was done actually by teleconference because it was a prison doctor, so I don't even know if it was an evaluation. It was done by teleconference, but there must have been a test at some point, because at some point they said that his viral load, and this is on page 10 of the record appendix, his viral load was 3,752,000 units, viral units. Well, anything over 800,000 is considered high. So, I mean, he definitely has this chronic debilitating disease. There's some implication in some of the, that he's to some extent making this up or fabricating it in order to get an expert. And I think in this case that is not true. So he established a condition that was specific to him, and the articles established the nexus. So I really think that the hearing examiner would have benefited from an additional analysis on this particular factor.
And what factor would that have affected, or which factors would?
Well, 31, definitely, the physical factor, and then possibly also 30. Now, my problem with that is that the examiner did give him, even though he was only 53, I think the examiner 50, he gave him full credit for that particular factor. But there is an interrelationship between factor 30 and 31. 30 is age, and in the age factor, they say that someone who is suffers from a physical condition is less likely, that combination of age and physical condition could make a factor. So if he had given full weight to factor 31 and combined it with factor 30, there is a possibility that the outcome might have been different.
I guess I wanted to focus you on that. So let's just say we agree with you that that your client merited, or it was an abuse of discretion not to give funds. What results? Is this a vacating of the classification, or do we analyze the classification in light of the other factors? That is, was there prejudice?
I really think that in this case there was prejudice. The courts have made very clear, both the appeals court and the SJC, that the hearings on these cases are supposed to be particularized and customized to the actual person. And if someone is unable to, if someone has enough physical disabilities that it compromises their ability to get around, or if it compromises their drive, that might have been a difference. So I think he is entitled to a remand. The attorney in this case did everything possible to lay the necessary groundwork. And I would just like to use my remaining time to point out that there was a case in June 20, 2019. It's an unpublished case, so I realize it's not precedent, but 523878 on June 20th, 2019, in which once again, there was a physical condition and medical articles were introduced, and this court found that it was an abuse of discretion not to have allowed funds.
Is that the diabetes case?
Yes, yes, and pancreatic cancer too, I think. I would also say that the judge, the judge relied on a case from 2008, 10-216, that has more or less been overruled in some respects. In other words, it's not quite as relevant to this issue as it used to be. And if there are no further questions, I will rest on my brief.
Looks like we may have lost Judge Maldonado.
Oh.
The clerk.
So why don't we wait and see if she logs back in?
You should assume that we are still live streaming.
Yes, would you like me to pause?
I think we should.
Okay, we are live.
I don't see the clock, but I believe I had 2 minutes left, and okay, and I did just want to say that there is a tendency on the part of the hearing examiners to deny these motions for expert funds because obviously an expert can be of aid to a petitioner. And the other thing is, if an expert does testify and does get involved, it tends to make for a much longer hearing. And the board is an administrative agency, and it has a goal of efficiency. So there is an inbuilt institutional tendency to deny these motions. And when the motions are denied, it may be efficient, but it sometimes comes at the expense of making an accurate determination.
I think when I got cut off, Justice Wendlandt had a question, so I don't know if it went on beyond that.
That moment has passed. I'm sorry.
That moment is passed. Okay.
I don't remember. Sorry.
That's okay.
If there are no further questions, I'll rest on the brief. Okay.
Seeing none. Attorney Chanel.
Yes, good morning, David Chennai for the board. I'd only point to the recent case on May 14th, where the Supreme Court in Doe 234076 specifically said that where there is a factor that deals with an issue raised by an offender in a motion for funds, the board does not require to grant funds. And in this case, factor 31 obviously covers the issues provided or proffered by the offender in this case. Additionally, on May 13th, the day before, it was a 128 decision from this court, Doe 3904, which specifically said, and that was also backed up in Doe 234076 that was talked about, is that if there's not a board factor that covers it, or the individual has a condition that impacts his risk or danger, then the board should give funds. And again, in this case, that nexus wasn't met. And that's been since Doe 89230. That's been the gravamen of all these cases is when an offender is basing it on a physical or mental health issue, they need to show that connection. And this individual
So if I could stop you, counsel, how is the sex offender to show the connection if he's denied funds for such an expert?
Well, in this case, he could have said, I suffer from sexual dysfunction.
So
But
let
he
me
refused
stop
to.
you there. If he had said that, then why would he need the expert? That is, if he had said, I have sexual dysfunction, and that was documented in the June 2016 telemedicine report, then he wouldn't need the expert to draw the connection.
Correct.
So
Correct. And
it seems like a catch-22. It seems a little circular. Give me funds. No, you don't get funds because you haven't shown you have sexual dysfunction conclusively. But in order to get funds, you have to say that you have the sexual dysfunction, which means that you don't need an expert to establish that. How does one, if you're in Doe's position, get around that?
If he had said, I've suffered from sexual dysfunction, I think the court could then say he should have been given an expert, because there's a direct correlation between, he's making that direct correlation between his condition and his sexual dysfunction, because sexual dysfunction would have an impact theoretically on someone's risk or danger. I'm not saying it automatically would, because it depends on the circumstances and what that dysfunction is. But at the same time, at that point, the hearing examiner would probably have been required to give the funds. I mean, when you look at Doe 5-2,
it's not the nexus between the hepatitis C and the sexual dysfunction that he needs the expert for. He needs, as I understand it, the expert to show, given that he has this long chronic hep C diagnosis, what effect that may or may not have on his sexual dysfunction, and therefore be critical in showing whether or not he has a risk to reoffend. So, if, for example, he had in June 2016 said, I have sexual dysfunction, he wouldn't need expert funds to show why.
Yeah, but it's not so much the showing why. The expert funds are to show if there is sexual dysfunction, how much that impacts his risk or danger. The expert isn't to testify, yes, he has hepatitis C, yes, he has sexual dysfunction. That's not, and we have that in the record if he has said, I have sexual dysfunction. The issue is, how does that impact his risk and danger? The whole idea of an expert.
So are you suggesting that it doesn't even, in some ways, the funds were requested for the wrong kind of expert, because, how it affects risk of danger would be more like a mental health expert, right? As opposed to a medical doctor that says this is what he has.
Well, that's one of the problems with the motion to begin with is, if you look at the CMRs, 1.16 says they've got to describe what particular type of expert they want. And in this case, they only asked for a licensed expert. They didn't describe what that expert was supposed to consider. And again, each case is different, whether it's a mental health issue or a physical issue. But again, once that's determined, the real issue is, can an expert help the hearing examiner to understand something about risk and danger that this individual has because of a certain condition? And even in Doe, the most recent case, Doe 234076, the Supreme Court said, if the condition and the evidence coming in about that condition is repetitive or with the rest of the record, then expert funds aren't needed at that point. And again, there was nothing in this motion that showed that this individual did have an issue that directly impacted his risk, requiring expert evidence to help the hearing examiner understand that for the classification purposes. I mean, the whole idea of the—
Let me toss that for a little bit, because his motion was more detailed than a generic I want an expert motion. It says, I have this condition, I've had it for years. I have symptoms. I took interferon, granted 8 years ago. I have symptoms consistent with some of the symptoms described in these articles and studies of men who have Hep C. And these studies show that men with Hep C are more likely than men without it to have sexual dysfunction. So I need an expert to help me draw that nexus. Why isn't that enough?
Because, again, all he had to do in his affidavit is say, he never said in any of the documents, I suffer from sexual dysfunction, or this impacts some part of something that would go to risk and danger. All he said is that I suffer from diarrhea, I suffer from skin irritations, and I have fatigue. None of those three individually or together are indicative of someone having a lower danger or risk for sexual recidivism.
But doesn't that contradict exactly what the examiner said? The examiner said, I see you have these three symptoms, and so I'm going to give the physical condition, factor 31, some mitigating weight. Are you suggesting that that was clearly erroneous?
Oh, no, because you...
So it's possible for an examiner to draw sort of common sense conclusions from symptoms, right?
Correct.
So it's not necessary to have an expert to draw common sense conclusions, like the examiner did here. What Doe was saying is, I need an expert to help figure out if I have the symptoms from which the examiner could then, using his common sense, say this has an impact on risk to reoffend.
Again, yeah, I think you look at Doe 234076, which says if the board has a factor that clearly discusses and covers that type of situation, there's no requirement to grant the expert funds. But more importantly, the hearing examiner considered the physical condition and basically said, I will give some mitigation, and that's within their discretion. But again, pointing out that there was nothing in. Sure.
I just want to interrupt. But what do you make of the fact that the hearing examiner, or do you agree that the hearing examiner also said the extent of the condition is unclear? In which case, if it's unclear, wouldn't then an expert be able to clarify, and maybe that would result in not just moderate mitigation, but full mitigation?
No, because what the hearing examiner was saying is that to invoke factor 31, the requirement is on the offender to provide the documents. And what the hearing examiner was saying, the documents provided didn't clearly prove that this individual had a reduced risk or danger because of his illnesses. But
because he didn't get an expert to show that. I mean, it seems that's what I'm talking about, the circular nature of this. It's, in order to get the expert, he has to show he doesn't need the expert because it's not burden on him to show the connection.
No, the court has been clear since 89230 that it is the burden on the offender that has the burden of showing the connection between their individual circumstance and risk and danger before the board is required to give the expert evidence, the expert funds. It doesn't say that, and again, it's very clear that the court in that case said this isn't a fishing expedition where someone can say, I suffer from this and it might affect me, so please give me expert funds. The court has been clear that's insufficient because, again, these are administrative hearings. These aren't proof beyond a reasonable doubt. These aren't expected to be battles of experts. Experts are used for basically two circumstances now. When the board's regulations do not cover the individual circumstance of that is being proffered, such as I had the case with the female sex offender, and the board's regulations did not cover female sex offenders. So that's a good example. The age issue before the board had an age factor, that was a good example. The second part is if the board has a factor, but this individual still has a condition that he can show impacts his risk or danger, then the board should give him expert funds. And this individual had that chance. All he had to do was explain that he was suffering from a condition that affected his, in this case, he could have said, I have sexual dysfunction. He refused to say that. You know, again, you look at some of the evidence the hearing examiner is looking at when they're deciding whether or not to grant the funds. There was also evidence, there was no evidence that he suffered from any kind of physical limitations. His behavior while incarcerated, while he had both the treatment and had the illness, showed no reduction in his ability to have problems in the jail, cause problems in the jail. So it's hard for the hearing examiner to look at this saying he's got some kind of reduced physical disability that somehow is going to lessen his risk or danger at this point. And I think that's really the bottom line. Is you follow the chain from.
If we disagree with you that this actually was an abuse of discretion to deny the expert funds, what then? I asked your brother the same question. Can we then say it wasn't prejudicial, or do you agree that in that case it is prejudicial?
It's not prejudicial. I mean, they have to establish, if you decide that the hearing examiner's decision not to grant the funds was an abuse of discretion, you still have to show the prejudice factor. Again, if you look at case law, these cases, SORB cases, an individual doesn't have substantive due process rights, they have procedural due process rights. So they have to show the prejudice. Now, you'd have to find, one, that it was improper, it was an abuse of discretion, and two, that he was prejudiced by it, but that the outcome would have somehow been different should he have been given an expert, or the chance of the outcome being different. And secondarily, in this case, you go back to the fact is what type of expert would have been required? Someone who's just going to review the doctor's records, give him a medical checkup and say, yes, it does cause sexual dysfunction, and I think he should be a 1. Or are you got to get a mental health expert that trying to coordinate this issue with libido and that area? That, again, you have to go to, one, was an abuse of discretion, which of course I, as the board's representative, say it wasn't. And two, if it was an abuse of discretion, was the individual prejudiced by this? And I see I'm running low on time. If I have any other questions, I'll rest on my brief.
Seeing none. Okay, thank you both. It's a good argument in the case.
I'll let you know. And we're live.
In the case of Carolyn G. Hefner and others versus Stephen P. Hefner, 219P0774. And counsel, you may begin.
Good morning, Your Honors. May it please the court, Attorney Heather Jo Williams. I represent Stephen Hefner. He's the appellant in the pending matter. There were several issues that were brought up in the brief that was filed, and I'd like to highlight some of the issues that were in the brief, as well as go into a little bit further detail. The first issue addressed is father's complaint for contempt. That's addressed on pages 27 to 29 of the brief. The legal standard relative to a complaint for contempt would be a clear and unequivocal order with an equally clear and unequivocal willful violation. The issue with this contempt is that the lower court judge summarily dismissed father's contempt, stating that after review of the totality of the evidence, mother was not found in contempt. So the issue that we have with we believe that is a misapplication of the law by the lower court justice. There is a case that is cited by my brother that does speak of the so-called totality of the circumstances. However, that phrase was utilized when looking at factual circumstances to determine whether or not in that particular case, that individual's belief about an income piece, was it reasonable for them to believe it was income versus reasonable to believe it was cash in of property, and then what that individual did based upon his reasonable belief under the totality of the circumstance led to a finding that that person was not in contempt. Conversely,
can I interrupt for a second?
Absolutely.
Let's say I agree that the judge worded how he applied the standard, or she applied the standard incorrectly. But then when I look through the findings, what findings did the judge make that would any way support a finding of contempt against mom, because the only thing I found was the $34, and that you can't say it was violating clear and unequivocal order, because there was no clear order that school supplies and are not to be collected. So there was like, okay, misunderstanding, school supplies really goes to the other thing. So that's the only finding at all that relates to mom from the contempt. So how would be able to say that?
Yes, Your Honor, and that's where I will get into some more specifics that weren't cited in the brief. The lower court did not go count by count as to the allegations of each and every specific instance that father alleged that there was a contempt. And the record was replete with specific instances that were incredibly clear as to dates and times where mother violated the order. So specifically, when you look at the record, there's this piece about a holy day of obligation. I disagree with my brother. A holy day of obligation was specifically defined by the parties, Record Appendix, Volume 8, pages 52 to 53. It clearly outlined what a holy day of obligation. Mother then, in the Record Appendix, Volume 11, page 934, and Volume 11, page 448, she admitted she did not take the children to church on those holy days of obligation. That was clear evidence that the lower court had that they just did not address in the findings. One of dad's allegations that mother failed to open and respond to the Our Family Wizard records, which we call OFW commonly. Mom did not open and respond to the OFW records in a timely manner, which is within 24 hours. Again, that is a clear and unequivocal order.
On the OFW, the way it seems like one could read the judge's findings was that the father was just putting far too many messages in there. So yes, she didn't respond, but he caused the problem and that she dealt with it in a reasonable way. So what do you say to that?
So what I say to that is that goes to part of the finding of contempt on father, that he was excessive in the messages. Mother was not responding. The order did not say mother doesn't have to respond if she thinks it's excessive or reasonable. The order is clear and unequivocal. Mother is to respond within 24 hours. And again,
you're saying that if the father then just bombarded her with messages, he could control her and she had no choice but to have to respond to every single one of them?
Absolutely not, Your Honor. I believe that if mother had responded to the messages, father would not have kept asking the same questions over and over. If you read the record,
on average, how many of these messages was he sending every day?
So it would depend between 2, and there would be several messages, and they were all relating to needing a response, and some of these things were critical. But again, the lower court ignored. We have Record Appendix that is a clear record that is Record Appendix Volume 11, pages 98 to 1344. There are 66 specific times. It is clear, 66 messages, OFW that dad sent, the time he sent, and the time that mom didn't even open them in time. That is black and white, unequivocal evidence. She did not respond, and she never denied it. She didn't put forward, I didn't respond because I was infirm. I didn't respond because my technology wasn't working. She didn't offer any response as to why she didn't do it. She just felt like dad asked too many questions, so I'm not going to answer it. That was a clear violation.
Are you saying as a matter of law, then she must be held in contempt?
Absolutely. I'm saying as a matter of law.
What is your legal authority for the proposition that when somebody ignores an Our Family Wizard message, let's just say she did it once, that they must be held in contempt because the order says that I shall respond within 24 hours? Are you saying the judge has no discretion at that time?
What I'm saying is in this particular case, the parties contracted a clear and unequivocal order, which was directly related to how they were going to co-parent so that they had communication, that each of them would respond.
So I'm aware of the factual issues of the case. I'm wondering what legal authority you're relying on for the proposition that this judge used his discretion in not, as a matter of law, holding mom in contempt for ignoring some messages for more than 24 hours.
So I am relying upon the cases cited in my brief about when there's a clear and unequivocal order. And I was not able to find a specific case that gave the lower court the authority to say, I can ignore a clear and unequivocal order if the defendant had a reasonable position to just not follow it. I could not find a case that said, if a defendant just finds that this was something other than, they don't have to follow the order. I was trying to find where the judge had support for what he did, and there was no finding. What is important to know is on top of this, so we have the 66 instances, it's clear in the record.
We're anticipating a legal regime where I contract to take my child to church on a holy day of obligation and I miss it once and I must be held in contempt as a matter of law. That's your proposition, that your cases that you cite in your brief stand for that.
I am saying in this particular case, with this fact pattern, with these parties who detailed how they were going to raise their children as co-parents.
But that sounds like a discretionary decision, right? Because now you're listing specific facts that the judge, in fact, probably considered, although I'll agree with you, the order is less than, doesn't expound on that. That seems like a discretionary decision. What you're asking us to do is find as a matter of law that there was an abuse of discretion because mom missed a holy day of obligation.
I'm saying as a matter of law, the lower court ignored each and every count of contempt that dad had. And another example of that is relative to the payment of all of these activities. The judge finds dad in contempt for not paying activities, okay? And relies upon, the only thing I can find in the record that the lower court relies upon is father's counsel in his proposed rationale put a number in of $7,112.70, record appendix volume 7, page 660. That is, then the lower court adopted that. That is clearly erroneous on the record. And again, the lower court ignored the factual evidence in front of them. Looking at the expenses that the lower court found father in contempt and didn't find mother in contempt for non-payment of expenses. Mother testifies that.
So I'm wondering how, I saw that in your brief. How is that related? That is, whether or not father is in contempt. Isn't that a separate inquiry as to whether or not mother is in contempt? You seem to be conflating the two, and I'm wondering.
Because they're the same expenses, Your Honor. They're the same expenses. So what you need to do, and I'm not sure why the lower court didn't do this. So when the lower court found father in contempt for the $7,000, mom had testified, record appendix volume 14, pages 489 to 490, that she was owed half of $600 for hockey. And then she referenced exhibit 41, which is record appendix volume 6, pages 718 to 723. And then counsel has inquiry and says, so what you're saying is the quote unquote open expenses are the expenses that are owed to you. And mom says yes. And then when the proposed findings go in, the lower court says all of the expenses on the sheet are owed, except for when you look at that exhibit 41, record appendix volume 6, 718 forward, many of the expenses are marked paid, many of the expenses are marked refused, and they're not there. The bigger problem is what father was saying, he didn't owe certain expenses because there weren't any receipts provided. What happens if you look at exhibit 41 of mother and contrast that with the record appendix volume 13, pages 7 to 113, which is dad's expenses, he was requesting reimbursement for the same expenses that mom was then awarded in the judgment of contempt. And when you look at what dad put forward as his evidence, record appendix volume 13.
I kind of lost the thread of your argument. Which issue does this relate to? Are you saying that the judge made a clear error of a fact in the
Correct.
number of expenses? And which issue does that fall under in your brief?
It falls under issue 1 relative to father's contempt being dismissed because there was clear and unequivocal evidence that mother owed him for expenses. And it falls under issue 2 as it relates to father being found in contempt because the calculation the judge used is incorrect on the record. If you look at volume 13, pages 43 to 112, the expenses listed total $1,570.01. Those expenses were posted by dad with receipts and canceled checks written by dad in the same amounts that then mother in her exhibit says she paid. Well, the evidence is clear. The check is written by dad. He paid 100% of that expense. And then in his contempt, he said, I want my 50% back. The lower court did not address each expense and each one that he had asked for, which were very clearly outlined and summarized in lower counsel's proposed judgment that was presented lower court. He just dismissed it and said, totality of the circumstances, and then adopted what mother's counsel put forward as being owed, when it is very clear on the record, mother didn't even pay them. So when the judge ordered dad to pay $7,000 of that amount, he was having him pay again half of what he already paid 100% of and wasn't reimbursed. This is part of a global problem that leads into the other issues. When I reviewed the record, pretty much everything that dad put forward to support all of his issues in the case, be it on the contempts, be it on the legal custody issue, be it on the legal fees, it was just ignored as if it didn't exist. And I recognize that on the custody piece, it can be difficult because there's a lot of discretion on that. But when you look at this case as a whole, there is clear, black and white. There's a canceled check for dad for a hockey helmet that is $156.97, Record Appendix, Volume 13, page 43. The lower court then said, mom paid that and dad owes half. I don't know how that happened. It's the findings of the contempt against dad are clearly erroneous based on the record. And I don't mean to rush, but I have very limited time. And while we're on the issue of the finances, again, the lower court summarily dismissed all of dad's arguments relative to child support and alimony. And it just doesn't make sense.
Now, on that, I'd have to take issue with you because while the issue of mom's contempt was dealt with in a paragraph, I think the judge was pretty careful in analyzing dad's finances and meticulously going over and showing why there was a de minimis change in that situation, not warranting a change either in alimony or under the two conditions agreed to by the parties that could warrant a change in child support. So how do you substantiate that statement?
So the issue that is with that is it's very clear that the court is to not include income and dividend interest derived from assets that were divided at the time of divorce and utilize that to calculate alimony. These parties were divorced in 2015. This modification came up in 2018. In 2015, both mother and father received equal amounts of that account that then created all of these dividends and interest. Dad did not infuse more capital. It just kept growing. Mom pulled all of her money out and bought a vacation home in Vermont. So now we come forward a couple of years, dad's income that child support and alimony was based upon, which was his working income, has substantially decreased. When you run the child support guidelines based upon that, if you run a 100% child support guideline based upon everything, including dividends and interest for dad, it's $1,511 per week.
But what were the conditions that the parties agreed to that could warrant a change in child support? I think you're missing the boat there.
They didn't include the interest and dividend income. Mom had equal interest and dividend income.
I'm asking you, what were the conditions that the parties agreed to in their settlement agreement that was incorporated into the judgment that would warrant a change in child support?
That father's income decreased, which it did. And then the child support guidelines decrease, which it did. And then if we run an alimony guideline excluding interest and dividend income from the asset received in divorce, that also comes, the combination of all numbers is less than what dad is paying any way you look at this. Any way you run the numbers, your honors, it becomes a lesser number. And what has happened is there's been a double dipping here. There has been including all of dad's interest and dividend into the child support. The lower court judge says, okay, well, your income decreased, but you made up for it in the interest and dividend income and the assets derived at the divorce pursuant to Section 34 division. So I'm going to keep your alimony the same. Well, that's not what the statute says. The statute reads to exclude that income. So in doing that, that was an error. And that was a pattern of errors where every argument that dad put forward was just dismissed as if it didn't exist. Even when there were black and white documents, contrary to what mother testified to, black and white, canceled checks, dad's signature. And then she testifies, everything that's owed on that list is owed to me. But she never provided proof of payment. And in fact, in the record, dad paid 100%. But the lower court, for reasons unknown to me, ignored all of dad's arguments, relied, the rationale that lower court entered is almost whole cloth, the rationale put forward by mother's counsel. And the concepts put forward by father's counsel detailing each and every incident where mother was in contempt, each and every incident where he was owed money, where there was a canceled check that he paid it, were just dismissed without any explanation, without any analysis. And that is exactly what happened with the child support and alimony, and that is exactly what happened with the custody piece. And the custody piece is a
counsel, your time has been expired. Let me just check, there are any questions? Seeing no questions, we'll turn now to to Attorney Smith. Will you be going first?
I will, please. Good morning. I'm going to address something that I just heard that's a little bit disingenuous. The separation agreement provided that child support could be modified when there was no longer any alimony obligation or any other material change in circumstance. That's on page 10 of the separation agreement. And it's finding number 25. It did not speak of a decrease in income. That's absolutely incorrect. And
can a decrease in income be a material change?
of course it can. A decrease in
So
income
isn't that what they're arguing?
No, they're saying that it's a mandatory process. That if there is a decrease in income, there must be a change. Now, there are a significant amount of cases that say that that's not correct. The Greenberg case, which we cite, is very clear that even a substantial decrease in income does not necessarily mandate a downward modification. That's not what happened here. And we really don't know if there was a substantial downward move in this particular.
Okay, let me say this. If it's correct that even a substantial decrease in income does not necessarily, the judge still has discretion to find that the orders of alimony and child support remain the same.
Absolutely.
Was it error for the judge to base it on the fact that the income has remained the same because of the dividends and interest, as opposed to say, I understand that I don't include the dividends and interest, but even this decrease in income, I'm not persuaded that I have to change the alimony and child support order.
The judge looked at the issue of the increase in the dividends and interest and said that
was that a mistake?
Not necessarily.
Why not?
Because what one has to look to change or modify are all economic conditions. And that's very clear in the Greenberg case. And what are the economic conditions? The economic conditions are that father's income in all manner, shape, and form has not really changed. His assets have not changed. His lifestyle has not changed. In fact, it's probably better than it was at the time of the divorce. His debt service at the time of divorce was $291,000. At the time of the modification, it was zero. Mother's needs have been decreased since the time of divorce. She's now juggling bills. Because father was estranged from the children, she has them all the time. And her obligation is solely dependent, her obligations for support and to pay bills are solely dependent upon father because she is a purely dependent spouse. So even if we say that there is a decrease, and the question is whether it's substantial, because in fact, the salary that was changed here changed approximately $29,000 a year. And that's not fairly substantial. He's still making, even with that, over $300,000. It changed from $333,008 to $303,992. So that's not a substantial decrease. It's a $30,000 decrease. This is a man who's maintained millions and millions of dollars. He also maintains his lifestyle. He manages to spend per week $482 for food. He also spends a per week $200 for entertainment, $300 for the Long Meadow Country Club, and $384 for vacations. So his lifestyle hasn't changed. So
counsel, the husband's attorney argues that the judge, in considering whether the husband's income had changed, because that's about a 10% drop, that she's arguing the judge improperly looked at the dividend and interest income in calculating his income. She says that was not correct. So what do you say to that?
I say that the judge has discretion to look at the totality of the economic piece, okay? And it's not clear that the judge relied upon his dividends and income for income. It isn't clear that that's the case. And it isn't clear that that particular increase derived from dividends and interest that came from a division of assets. The division of assets took place at the time of the divorce, which was the same time that this order was entered. The conditions still exist now, as they did then. His income.
Counsel, something happened. I mean, if you have a decrease in income from 330,000 to 303,000, it's not quite 10%, but it's in that ballpark. And this judge said 0.97%. So how do you get there?
Well, the 1% doesn't make a lot of sense. So, okay, because then you get to the 1% by including the income. Of course you do. But 10%, even if he made that, it's not a fatal error. Because if you look at this case in a deeper sense, you have to look at the judges, not the judges, but the issue of whether or not the father's situation has changed, the mother's has changed, and whether or not there is a material change in circumstance. And that's the bottom line. So I say that if the court did that, made that 1%, that's not an error that should require the court to overturn this. There's still sufficient evidence that the father had the capacity to pay alimony, and there was sufficient evidence that the mother needed it. In fact, he needed it more at this point in time.
So what do you say to her arguments that the father paid certain expenses, the record shows he wrote the expenses, and now the judge is making him pay those expenses again?
All right. So what I'm saying to you is that that's not, as I read the record, the court on the contempt question, the court carefully considered father's allegations in the context of the totality of the evidentiary record, okay, not totality of circumstances, the record. And
is that how he's supposed to calculate it? I mean, isn't contempt, whether someone's in contempt, whether the actions support a contempt? Not, you know, I'm going to look at how everybody's behaving here. And when I look at how everybody's behaving, I'm not going to find that she's in contempt. I'm only going to find
but no, I didn't finish. He concluded that there was any willful violation of the orders by the mother. So you do have to look at various pieces. No, the court didn't look at piece by piece. But if you look at piece by piece, which we try to do in our brief, we talk about how mother tried to facilitate the relationship, how with the children, how she initiated and reminded the children about communicating with her father, how she tried to respond to father's OFW messages, even when he'd sent her threats about the police, her committing adultery, sending her the statutes, sending her threats about juvenile court, sending her all kind of excessive and frequent.
So he was found in contempt of that. But two wrongs don't make a right, right?
No, but
it's sort of like if you can't pay child support, you can't pay alimony, you don't sit back and just say I can't pay it. Your obligation is to go into court and get a modification. So wasn't her obligation when this started happening, go in and find him and get him in, get the court to see he's in contempt before she put herself in the position of being in contempt? So
in terms of the payments, many of those payments that he claims were not made were gifts, which is what the court found.
Okay, maybe I missed, I was just using that as an example. What I'm saying is one's obligation when you have this is sort of a contract is not to ignore it, but to go in and say this person is in breach, they're in contempt, and I don't want to be in contempt. How can we change this? Not to just nor your obligation under the.
No, of course not. And that's why I said in my brief, we tried to address factually what mother did with respect to father's allegations, piece
So the
by piece.
problem I have is that you addressed it factually, but the judge didn't.
Record supports the finding. Okay, and that's where we say it. Even if the judge doesn't specifically address it, the record supports it. And if the record supports it, that's satisfactory under a contempt finding. That's our position.
Okay, seeing no questions, Attorney Jordan.
May it please the court, Your Honor. My name is Amanda Jordan. I represent the two minor children in this matter, Patrick, who's now currently age 16, William is now age 12, and I would largely rely on my brief responses. I would just like to take issue with two issues raised in the appellant's brief. First, relative to whether there was a finding of a material change in circumstance and whether that was required for the court to order a change in custody. And I think that in this particular case, what is important is that both parties essentially in their complaint for modifications were arguing for joint or for sole legal custody. Father prefaces it with asking for sole decision-making, mother asking simply for sole legal custody. In actuality, they are essentially the same character. In sole decision-making or final decision-making authority, you're essentially saying there needs to be some communication and then I get to make the final decision. And so father in his complaint for modification essentially argues that there's a change which would warrant joint legal custody, which the parties agreed to in a separation agreement in 2015 was necessary. If the court wasn't persuaded that in itself was a material change, the Macri case, which I cite in my brief, also indicates that the court can infer a material change of circumstances if it's in the best interest of the children to make a change in custody. And therefore, I get to the bulk of my client's positions, which is that a change in custody was necessary for their best interests. I think the court spent a majority of its time capturing this for the court, made findings relative to the fact that these parties could not co-parent, that our family wizard had become for lack of a better word, a misuse between the parties for communication, that it was not serving the purpose, which was to facilitate communication, and that as a result, there was significant stress that was being put on not only the parents, but specifically my clients. And that was primarily seen in the estrangement that my clients experienced about 8 months prior to trial and continued through trial and has continued. These parties have tried co-parenting. There was not success. The court found that in volume 1, page 358. There was a guardian ad litem appointed in this case, a Dr. Gerald Lewis, which all parties agreed's report was part of the record. And he found that the parties had no ability to co-parent. And so case law from our perspective is clear that when there is an inability for the parties to co-parent, that parenting needs to be assigned to one parent or the other. It is our position that that parent was appropriately being assigned by the lower court to Ms. Hefner. The court here has to look at whether that was an abuse of discretion, and the lower court backed up that finding quite well, I think. You know, while there are maybe other issues in this case that have led to some questioning, this particular issue was addressed very directly by the court head on, and there was significant reliance not only on the record, but on the testimony of the parties, and that was referenced in the judge's own findings. The father relies on the custody of Zia as showing that, well, due to mother's actions, it was inappropriate to grant her legal custody. And so I just want to take my last 30 seconds or so and say why that particular case in this particular instance is not appropriate, and that case shows or stands for the premise that mother was actively thwarting father's interaction with the children, actively thwarting the relationship. In this case, that was not found by the lower court. It was not found by the guardian ad litem, nor some of the other professionals in the case. In this particular case, there was mitigating circumstances that the judge indicates were found, and that did have to do with the degree in the exchange of the Our Family Wizard exchanges. And I would just further rely, Your Honor, on page 21 of my brief where I outline how that case is distinguished. Thank you, Your Honor.
Let me check if there are any questions. Seeing none, the case is submitted. Thank you all.
You're all.
Get on all sides. Thank you. Calling the case of Thomas P. Healy and another versus Clifford L. Hagberg and another 219 P 1037. I just forgot before we begin, if there are any technical difficulties, you get logged off, just log back in, and a time clock for the 15 minutes will replace the seal. So with that said, I can begin. Counsel.
Good morning, Your Honors. Tracy Taylor for the appellant, Clifford Hagberg Sr., to whom I will refer as Mr. Hagberg for ease. Your Honors, this appeal stems from issues of breach of contract and negligence. It stems from a complaint that was filed in 2014, and the complaint relates to a cause of action that accrued back in 1988. It was back in May of 1988 that the plaintiffs entered into a written agreement to purchase a flexible interval timeshare unit from Mr. Hagberg in his capacity as trustee of the Beach Realty Trust. The consideration for the purchase was $10,500. $2,100 was paid in cash. $8,400 was financed over a period of 7 years, Your Honor. The deed on its face does say that, the agreement does state on its face that the deed will be recorded within 5 days after the financing is received. The deed also states on its face that it is a flexible interval timeshare. And if you look at paragraph 10 of this agreement, it again acknowledges that this is a flexible interval timeshare. It's not a set unit. It's not a set time. It basically grants the plaintiffs the right to reserve a unit at the condominium during the high months of the year. So that would be.
So when it says reserve the right to a unit, it's not a particular unit. It is a unit that would have the comparable rooms and
Exactly, Your Honor. And that is delineated not only.
But you seem to acknowledge in your briefing that the unit they were offered in mitigation was not the same unit.
It was not the same unit, but it had the same rights and privileges as the deed. Because
but then that sounds like there's a tie to a particular unit.
For purposes of recording, it is. But if you read the master deed, and there is, it's entitled Flexible Timeshare Interval Privileges, which is an addendum to the master deed. And the deed itself, the agreement itself states that the plaintiffs acknowledge that they had read these timeshare documents, including the master deed and all of its supplements, which say that this grants the buyers the right to choose any type of unit during the high months of the year, May, June, September, and October. So although the
do they get a first choice, or do they just have to, it's whatever's available at that time when they choose?
Yes, it's based on a reservation system, Your Honor. So first come, first choose. They're entitled to choose their type of room during the high season. And this was not contested at trial. The manager of the resort testified that a flexible interval meant they get to The plaintiffs could choose which type of room they wanted during any of the 4 months of the high season, and that it was based on a reservation system. And the plaintiffs acknowledged that. So they knew what they were buying. They knew they were not buying a set unit. They knew they were not using that one unit once a year, but that they had a reservation system and they would choose which units and which week they wanted. But they had 1 week during the high months per year, Your Honor. In any event, the deed was not recorded. The plaintiffs admit that they never inquired into the recording of the deed, why they hadn't received one. In fact, the promissory note was paid off in 1995, Your Honor, and the bank sent the plaintiffs a notice that their promissory note had been paid off and the mortgage discharged, and a letter that stated that this would be recorded with the Registry of Deeds. Well, it never was, and the plaintiffs again in 1995 didn't make any inquiry into this. And it wasn't until 2013, the fall of 2013, when the plaintiffs decided that maybe we don't want this anymore, we're going to try and sell it. And they talked about selling it to a friend. The transaction never happened, Your Honor. In fact, the trial evidence is clear that although they discussed selling the timeshare, they never entered into any real negotiations for it. And the woman who was contemplating buying it never even looked at the condominium association. Nevertheless, Mrs. Healy's testimony was that she was thinking of selling it to this woman for $2,500. At this point, she discovered she didn't have a deed to convey. So at that point, she approached the successor in interest to Beach Realty Trust, the Ocean Trust condominium, and they looked at their books and says, yes, you know, we see nothing was recorded. We don't know why, but we're willing to offer you another deed that will grant you the same rights and privileges as the deed that should have been given to you back in 1988.
Well, you pay us $500 more, right?
Exactly.
And
Yes.
Do you have a case that says that someone has to spend money to mitigate their damages?
I don't have a case that says that they have to spend the money. I have, you know, they have an obligation to mitigate. That's my position. Had they purchased this, it wasn't a purchase, it was paying the recording fees. They would then have been able to sell their timeshare interval for whatever it was worth. And we allege
Right,
that.
you're saying that they would have had to have risked a bigger loss to try to get a smaller loss. And I'm not aware of any case that says that parties are required to do that.
I will concede that, Your Honor.
So is this proposed deed in the record somewhere?
The proposed deed is not in the record, Your Honor.
And so when you say, so go back though, because you say that what should have been recorded was not a deed to a set unit. And how are we, I want to know what in the record I could look at to understand that.
You could look at the trial testimony of the manager of the unit, the manager of the condominium trust, which is, I'm looking for.
but that seems to be something that should be proven by documentation. I'm wondering why you're pointing us to testimony. It almost necessarily has to be proven by the document.
Well, the document on its face, the agreement states that this is a flexible interval unit and that it affords the party, the purchaser, the right to choose a room during the high time. And that's on the face of the agreement. It's also in the master deed to the condominium trust. And it was not contested at trial. The plaintiff admitted that in the course of the trial, that's in the transcript, Your Honors, that she acknowledges she knew she was buying a flexible interval interest, timeshare interest. The manager testified that that's what it was, and the plaintiff acknowledged that. So it wasn't contested at trial. This was not a contested matter.
So counsel, do you have a case that supports the idea that a different deed would suffice for mitigation purposes?
I don't have a case, Your Honor. I don't believe this issue has ever been addressed as it would be an issue of first impression.
Which is,
But I would,
go ahead. I'm sorry, I didn't mean to cut you off.
I would suggest to you, Your Honors, that the damages in this case, which the judgment was entered damages as $18,668.75. That was the exact amount that the plaintiffs paid for this flexible interval timeshare interest. But the plaintiffs, and they admit this, and this is uncontested in the evidence, Your Honors, they had the full use and rights and use and access to this flexible interval timeshare. Throughout the 30 years, they continued to have the full rights and access. They've never been denied access. The deed was not recorded, but they still had the same rights and access. And they admit that. The damages
was the deed. I know that you're saying it's and everyone agrees that it's a flexible interval timeshare, but for purposes of recording, a particular unit was supposed to be deeded to them. Was that unit then had it been deeded to somebody else by the time this litigation came up?
It had. That unit had been deeded to somebody else. But as I say, the unit designation was for the purposes of allotting the plaintiffs a choice in when they got their vacation. What months, the unit designation, unit 2, interval 36, was a designation for purposes of recording and granting a fee simple, but in terms of the rights that it conferred, it was a right to choose which week you were going to take your vacation during the year. And so for
counsel, I mean, if you wouldn't need to have a whole timeshare deed situation, if that, you could just say, you have this right, we're just selling you this right completely untethered to real property, but your client chose to set it up in a different way to say you're getting this particular deed. So why should we now take him out of that and just say, oh no, that's not really what you were getting. You were getting a right to a particular week during a time frame.
As I said, the agreement states that this is what the agreement states, you're getting a flexible interval. It says that, and for purposes of recording, preserving the plaintiff's fee rights, the deed needed to be recorded. But the master deed to the condominium indicates that it's a flexible interval condominium timeshare and fully sets forth how the obligations and the rights of the plaintiffs to have their choice of rooms during these 4 months of the high season, Your Honor. So they had the use.
Well, I'd like to turn to a couple other issues that you raised. So you raised the issue of Mr. Hagberg's liability individually. The judge denied that motion. Why is that not implicitly a finding that Mr. Hagberg did benefit individually?
The judge did not deny that. The judge, in his rulings of law and in his order for the entry of judgment, directed that judgment enter against Mr. Hagberg in his capacity as trustee of the Beach Realty Trust. It was the clerk who then incorrectly entered the judgment.
Then you filed a motion to correct and the judge denied it, which is, I think, Judge Henry's point.
Yes, and we would argue that that's an error of law. He made findings during the course of the trial that it was Mr. Hagberg as trustee.
What legal principle do we use to differentiate between him as an individual and him as trustee?
Well, him as trustee, his actions would be confined to what he did as a trustee. I don't believe that there was any evidence offered at trial that Mr. Hagberg was the direct beneficiary of the money paid. All the evidence at trial was confined to Mr. Hagberg's actions
so
as
the legal test that you're positing, if I understand you correctly, is that he individually needs to have benefited from the failure to record.
If judgment is to enter against him individually, there must have been evidence. There should have been evidence to that regard. There was not. And I suggest to you that that's why
and the cases that you cite, I'm assuming in your brief, that set forth that legal principle.
Yes, Your Honor.
Do you happen to know which? It's okay, I can find it.
Okay.
Running short on time, but I just,
Yes.
if you knew
Yes.
offhand, because it seems to me that's
The other-
important.
So I know we're running short on time, so let me just sum up. I feel that the court,
Counsel, I'm sorry, I do have one other question.
sure,
You argued that the trial court did not appropriately set off the $17,000 or $17,500 paid by the other defendants. The plaintiff's response to that is that their damages were about $35,000. And so the judge did properly offset for that settlement. So what do you say to that?
I say that what they discussed at trial was that the plaintiff's total damages, including the annual maintenance fees paid to the condominium, were $30,000. And the judge did not make that finding. He did not find damages in the amount of $30,000. He found damages in the amount of $18,688, which is the exact amount that the plaintiffs paid for their timeshare interest. And that if in fact the judge had found $30,000 in damages, which he clearly didn't because he didn't say so, to then deduct $17,000, that would have left you with damages of $13,000.
But isn't a more reasonable interpretation of what the judge did is that these are the damages caused by this particular defendant as trustee? Why would the judge go into the details of what the other defendants who've settled out damaged the plaintiffs?
He didn't, but they were the same causes of action, breach of contract and negligence.
Okay. All right. No further questions, and we'll turn to Attorney Bland.
Thank you, Your Honors.
Good morning, Your Honors. I'd like to, based on that discussion, at least bring to the attention of the court that Chapter 183B, Section 2, distinguishes a timeshare estate, which I believe this unit was supposed to have been, from a timeshare license, which is this transitory thing that can be used from time to time in high season or for trading with other resorts in Mallorca or some other place. So I don't believe that the flexible timeshare issue really solves the question here of what happened to the deed from Beach Realty Trust to my clients. The Healys really don't have, at this point or at any time, the luxury of selling anything, since the deed that they contracted for was never given to them. In fact, I believe there's testimony during the trial.
Counsel, can I ask you, why is the defendant individually liable?
I believe that it must have been in the mind of the court, and also in my mind, and that that Mr. Hagberg, who was the principal of Beach Realty Trust, also acted as a fiduciary for the buyers when he offered to hold their deed and issue it when the financing was approved. He never did that.
But why would he be doing, even if he were a fiduciary, why wouldn't he be doing that in his capacity as trustee?
Because if you look at the purchase and sale agreement, it says that he will hold it and then record it. And
That he will?
yes.
But I thought Victoria Colburn signed that agreement. Who's that? It's not the trustee.
I believe she was his secretary.
So you're saying that she was signing on his behalf?
That's correct.
And that was argued at trial?
I believe it was, Your Honor. I can't remember that fact.
Right, that seems important, because if the trustee doesn't sign the P&S, you have a problem getting him to be individually liable.
I understand, Your Honor. I know from various real estate transactions I've been involved in over the years that in a situation like this, the trustee more or less is always personally a guarantor of all the loans for the development of the condominium and is personally involved in every aspect of the transaction. This is not.
Where can I find that in the record, though? I understand and appreciate your own personal experience, but I'm confined to the record.
I don't know, Your Honor. The purchase and sale agreement and the condo documents are included in the record. There is no background on the Beach Realty Trust because they couldn't produce it. They couldn't find it. So we have no idea what it is. And as far as their personal guarantees, once again, we have no idea because they couldn't find any records when we started the trial.
Now,
So why is the measure of damages? I'm sorry, go ahead.
I was just going to get actually to the same point. You had said that that the problem here was that they don't have a unit that they can now sell or transfer, and that's where the damage comes from.
That's
But
correct.
what they had, but you'd agree that although the deed was to a particular unit, it's the interest for that 1 week in the high season is what they would be deeding.
Well, they actually had a specific unit,
Right.
Unit 2-36, which you could physically walk into. And,
Okay,
and
I see. So let's say then that the issue is that they're not able to sell that unit. Why isn't the damages the fair market value of that interest in that unit and not the $34,000 that you, that was.
that they had to spend? Your Honor, the answer to that is that because of this, let's say, mistake, although I would feel stronger that it was a fraud, they paid interest on something they didn't own. They paid condominium fees and they paid assessments over 30 years, hoping that at the end there'd be some opportunity to sell the unit. They didn't use it that much. They were
But
owning
it's
it.
irrelevant if they used it or not, right? You know, if I buy a house in Vermont and I never use it, it's irrelevant. And it gets heated and everything like that. It's irrelevant whether I ever went there. And if the time I go to sell it, you know, the market flawed, well, that was a bad investment that I made.
Well,
But it would just be, I don't understand why the damages is, you know, the interest and the condo fees or the assessments, because the mistake here is in the recording and the damage is in their inability to sell it. So why isn't the damages there what they would sell for?
I believe, Your Honor, it was because they were induced to make these payments when there was no hope of them ever recouping anything from the investment.
So you're saying that the damages measure should be the amount required to put your client in a position they would have been before the breach, right? That but for the breach, they would not have expended the $34K that they did.
That's correct, Your Honor.
But the breach is in the recording. So not but for the breach, they wouldn't have expended it. They expended it based on the recording. I'm not. So so they expended after the decision to enter the agreement, and that agreement included the interest and the assessments and the condo fees. So I don't know how, but for the failure to record, you get that the damages are, I wouldn't have gone into this. I wouldn't have,
I understand the problem you're having with it. I think that it became clear during the trial to the court that there was more involved here than just failure to record. But of course, that's.
Judge did not make a fraud finding.
Well, that's true. But he did feel that it was inappropriate behavior on the part of Mr. Hagberg.
So he implicitly made a finding that this was a material breach.
I think so.
Can I ask you about the statute of limitations? Why has that not run?
I'm sorry, I didn't understand you.
Why has the statute of limitations not run?
That's a question that we spent a lot of time on, Your Honor. The cases that were cited by Hagberg were some of them were relatively appropriate. Others were totally inappropriate. But I think the discovery.
Well, let me just ask you more specifically. So in 1995, they finished paying this off. They don't get the notice that it was paid in full. At that point, aren't they put on inquiry notice to figure out?
Well, I don't know, maybe you and I as attorneys would be, but.
No. I'm talking about the reasonable person paying off a real estate investment. Having paid it off, wouldn't a reasonable person be on inquiry notice, at least to investigate as to whether or not
Well,
this deed had been
Your Honor,
recorded?
I'm not sure that these people were that sophisticated. I mean, the guy is
It's not a subjective standard. We can agree to that, right? It's the objective standard. And here, the whole point was to record the deed, right? And the absence of a recording, usually recording is enough for notice. It seems to me here, the absence of a recording, having now paid in full the unit, is a problem for your client.
And then having been notified that the mortgage is satisfied.
Your Honor, I don't think that they would have, they certainly didn't think of going to the registry and going into the land court section, which is obscure enough for lawyers.
But they could go to Hager, and I mean, they could go and.
He was out by then. He had filed bankruptcy and was gone. They didn't go to him. They went to they certainly had later gone to but only in 2014, to get the copy of the deed from the management office. They of course didn't have it. But before that, they assumed everything was fine.
But they can't assume that. I mean, that's why we have statute of limitations, and that's why we have a standard, right? And you know, it seems like you don't get a document you're supposed to get after you pay. You wonder, where is this? You know,
Your Honor, there is one case that Hagberg cited in the whole discovery issue. It's called International Mobiles Corp versus Courtroom and Black. And within that case, there's a referral to a citation from Melrose Housing Authority versus New Hampshire Insurance. And that was all about what was hidden in the wall of a building where condensation had formed and rusting or some other kind of deterioration had happened. And that wasn't in any way ascertainable by the casual observer, even a diligent observer. You have to hire a professional to take the wall apart and find out where the leaks were. That's the rest of these cases that were cited had to deal with employment or sexual abuse. That's
maybe
covered.
Because it's so obvious that when you pay something off, you get your deed. Whether you pay your car off, you get your deed. Whether you pay your house off, you get your deed.
I understand, but I don't think that someone who has a $2,000 or $3,000 or $10,000 timeshare in Yarmouth is going to spend time to hire a lawyer and to go look into the Barnstable Registry of Deeds to see if there's a deed there. They just don't do it.
But wouldn't they have gone to the association and say, hey, I want to just check my deed because I didn't get it in the mail? Why isn't?
They didn't. And
they did that in 2000. If they can do that in 2014, why couldn't they do that in 1995, 96, 97, 98? You know, 6 years they had.
During that time, they were just using the place and they had no issues. And, you know, that was it. And they didn't really get concerned until they wanted to sell it. And that's what triggered the inquiry.
Did you bring a fraud claim?
I believe I'm not sure we did. I can't remember here.
Do you agree that the judge was obligated to offset the settlement payment by the other defendants?
I did when we had a colloquy during that and described the $30,000 claim versus the $17,500 payment. He mentioned an offset, and I said, "Okay, Your Honor, that makes sense. Makes sense to me. Offsets I'm familiar with, deal with them a lot." So there was no dispute between the two of us. Of course, that's not a binding on anything, but he did understand it, and I understood it, and that's what I thought was going to happen, and that's what did happen, at least as far as his findings are concerned.
All right, you still have 2 minutes on your clock. I don't know if you have anything else to argue on.
I don't think so, Your Honor. I have,
Okay. All right.
I know
Let me
that
just-
I will say one thing, just to clarify. There was an offer of a free unit, well, so-called free. You had to pay the legal fees, and that varied depending upon who you asked what the legal fees would be. But that offer didn't come from Hagberg. It had nothing to do with Hagberg. It came from the condo association, and it was the first opening offer they made to settle the case. I brought a case against everybody, the condo directors, the successors, the management company, and at least the management company and the successor directors agreed to negotiate and settle the case, which they did. And they started with offering a free unit, and we said, no, we don't want any part of that because now we find out what's happened. We just don't feel good about the place. We'd rather have our.
I'm assuming, counsel, that these discussions aren't privileged in any way.
No, yeah, but at any rate, the offer was by them for a condominium unit that they didn't want, and so they've got a different settlement, which was cash, which is what they did want. So I don't see how that's in any way related to Hagberg, except it would have been.
Is there any evidence about what one of these timeshare units would be worth if it were sold at the time these people wanted to sell it?
There's a self-serving offer suggestion by Hagberg Jr., his son, that it's $2,500. I don't know. That may be right. We don't know.
But no one put any evidence as to what that amount would be.
No.
So can you explain how it was you got to your theory of damages?
You mean as far as the $30,000? Yes, Your Honor. I added up all the expenses that were paid by my clients. I looked at all the checks, added them up, the condo fees, the assessments, and the payments to the bank in Cincinnati, and added a time value of money of 5%, I believe.
I guess I'm still, and I know you answered this, so I don't really need to belabor it, but I'm still stuck with how is that representative of the breach here when the breach is the claim? I wanted to sell it and couldn't because I didn't have the deed recorded. But we'll look at your arguments again and see if time is up.
Okay.
All right, that's going to conclude this session. The case is submitted. Very interesting case and very well argued. So thank you. That's going to end our session for today. You're welcome to leave.